Hello and welcome to this webinar brought to you by World IP Review and the law firm Gorodissky Partners. I'm Tom Phillips, Group Editor of World IP Review. Wherever you are listening in from, be it home or work, thanks for tuning in and I hope that you are staying safe. Today we're heading to Russia to hear all about the anti-counterfeiting strategies in the country and the wider region. Now, brands operating in Russia face some unique challenges, not least due to the web of jurisdictions in the region that need to be taken into account. This can mean that a one-size-fits-all approach to these mostly online threats won't do you much good. What can help is a tailored approach. For that, though, you need a lawyer who knows the way around the region. So we're lucky to have with us today Evgeny Alexandrov. Evgeny is a trademark attorney and head of the legal department at Gorodissky Partners, and he is going to reveal some strategies to combat this problem. Before we get started, a brief bit of housekeeping. If you want to put a question to our speaker, please enter it into the questions box on your screen during the webinar, and we'll try to get to them at the end. Also, please remember that we are all broadcasting from our homes today, so apologies in advance for any background noise or interruptions. And that's all from me for now. So I'll pass over to our expert for today, Evgeny.
Yes, thank you, Tom. Thank you very much. And good afternoon, everybody, ladies and gentlemen, and thank you for your time that you decided to join our webinar, which is dedicated to anti-counterfeiting issues in Russia and neighboring countries. So as you maybe know, our law firm is the largest in this region, and therefore we have extensive experience in fighting counterfeits in Russia as well as in neighboring countries, in the countries of the former USSR. As you may understand that legislation in different countries may differ very significantly, and therefore in order to build up the effective brand protection strategy, it is necessary to have a legal team and lawyers from those jurisdictions in which the brand is affected or attacked by counterfeiters. And in this regard, in this presentation, I will tell you about specifics of fighting of trademark infringements on the internet, especially in Russia, but you can spread this information to other countries, and you may understand that they also may have some specifics, and therefore in order to ensure the most efficient brand protection strategy, it's necessary to have local lawyers in team. Of course, most of brand owners deal with online monitoring, and they use global providers for these services. Sometimes it is indeed very effective to deal with a huge number of infringements worldwide through just one supplier of the services, but sometimes this may just allow to remove a part of infringements, but the rest, and in the terms of money, can be the major part of infringements will also remain, and therefore the local lawyers can help to overcome these issues. Just to understand what is how big is the problem, so let's talk about some figures. And this is just the evaluation of global e-commerce market worldwide. And as you can see on the right bottom side of the slide, there is information about the development of e-commerce markets in Russia, and you can see it's increasing from year to year. We don't have official statistics for the year of 2020, but we have forecast, which is, I suppose, is quite realistic, especially taking into account that currently, in view of this virus situation, most people prefer to buy goods online rather than to go to shop, and therefore the amount of online sales is increasing. And by the way, I would like to say that when we deal with in such types of infringements, like trademark infringements on the internet, using our own platform, we see the increasing number of infringements in tobacco industry. Especially it concerns the online sales and of counterfeit products. And If you look at this comparison table with respect to share of global markets, we can see that China is the biggest online market in the world, and if we talk about Russia, it's just 2% of all global market. That's about $20 billion. But nevertheless, as I said, the market is growing significantly. And if we talk about Russia, we should understand that Russia is a member of Eurasian Economic Union, which consists of 5 countries, including Russia, Kazakhstan, Belarus, Armenia, and Kyrgyzstan. And there are no state borders between the countries and no customs borders. And the goods can move without any customs control between the countries. And therefore, it makes necessary to think about the legal protection for brands and for taking legal actions in all 5 countries in order to ensure the effective brand protection strategy. Because if the goods come from China to Kazakhstan and from Kazakhstan to Russia or to Belarus or to other countries of the Eurasian Economic Union, the customs will not stop those goods, and therefore it's necessary to ensure the protection of trademarks at the customs, to register the trademarks in the customs site, to register in every country of the Union. In future, there will be unified IP register in which it will be possible to register the IP rights, and the register will cover all 5 countries, but currently this legal act is not effective yet. And according to forecast till the year 2022, so the number of selling of counterfeit goods will be increasing. Although now we have about $460 billion US, meaning that every third product sold on the market is counterfeit, and the number will be increasing and even doubled by the year 2022, and therefore obviously it's necessary to take actions and to care about the fighting against spreading of counterfeit products. And therefore we can also see from this diagram that in comparison with other illegal activities, including sales of drugs, gambling games, and etc., the sale of counterfeits consists about 50% of all shares of all illegal activities, meaning that all money are around the selling of counterfeit products. And in order to ensure the revealing of counterfeit products online, of course, it's necessary to use some automatic tools for monitoring the search engines, social media platforms, marketplaces, etc. These monitoring tools allow to reveal the infringements. And therefore, it is important to understand that, for instance, in Russia, advertisements on local marketplaces and in social media are placed in the Russian language. And therefore, if you deal with global providers who use just English language, so it's absolutely will get 0% of success rate in fighting against online counterfeit strategies, and therefore it's necessary to deal with those who can work in the Russian language. If we speak about Ukraine or other countries, so therefore it's necessary to take into account the local laws, and it's necessary to take into account the requirements of local platforms and the coverage of the platforms actually. For instance, all we know some major marketplaces and social media platforms, and therefore it's wise to monitor all of them. But if we speak about the local market, there are local marketplaces which are unknown to local people who sell and buy products through this marketplace, and therefore it's necessary to monitor them as well. For instance, in Russia we have more than 300 local marketplaces which are very popular in Russia, and people from different parts of Russia sell and buy products through these marketplaces, and therefore, in order to reveal all counterfeit products, it's necessary to monitor all of them. You know that Russia is a very huge country, and we have lots of cities and lots of regions, and in each region there are also can be different languages used by people living there, and therefore it's necessary to have tools for monitoring all such marketplaces. This is just an example when we compared the results of work of global provider and local monitoring companies. So as you can see with this green share, which is about 770,000 items sold on the website auto.ru, they weren't revealed by global company only because of language issue. Therefore, if you don't know the Russian language, you don't know the specifics of the marketplace and don't know the language, you can miss a huge part of information. And besides, some marketplaces may have special requirements. So when working in Russia and doing anti-counterfeiting job here, we should understand that the Russian marketplaces and different platforms may have certain requirements. For instance, in Russia, there is the hugest marketplace called Yandex Market, and this is the famous one and the biggest one in Russia, and they have their own policy. So usually marketplaces are cooperative, and if you send them a cease and desist letter or take down notice, they may remove the offer from their platform, but Yandex Market truly believes that they cannot infringe somebody's right, and this is a matter between the seller and the brand owner. But Yandex Market is not a court, not a law enforcement authority, and therefore they don't have to remove the offer just on the basis of complaint of the brand owner, and therefore they refuse to remove the offer. And in most cases, when service providers send takedown notices to Yandex Market, they get zero success rate working in this platform. But there is another side of this issue. So Yandex Market, this is a good example actually. And Yandex Market is being the hugest marketplace in Russia. They provide the buyers with all information about the seller. And therefore, what usually we do, so usually we collect information from this marketplace and structure it and analyze, and we can get exhaustive information about the seller, including his name, his address, his website, his phone numbers, and etc. After that, we have a chance to send a cease and desist letter directly to the seller or to talk to him. In most cases, it allows us to reveal the chain of supply of the products to Russia, because this seller, who may understand that he infringes the law if the goods are counterfeit or parallel import, he may disclose all information about his supplier, and even provide us with copies of contracts showing that he bought the goods from a particular supplier. And it allows us to move closer to the main target, to the wholesaler. And therefore, so even taking into account that this marketplace usually refuses to remove the offers from the marketplace, nevertheless, this marketplace allows to be in touch with the infringement and deal with him directly, which sometimes is even more efficient because we can get not just removal of offer from the marketplace, but also information about supplier. So as you can see that on the left side of the slide, there is general approach which is applied by monitoring companies which do online monitoring work, analysis and sending takedown notices automatically. That's good. It works in many cases. But what we face in Russia, so very often the infringers ignore such takedown notices because they understand that a foreign company being a service provider is so far from Russia and they can do nothing against them from the legal side. What we usually do, so we usually communicate directly with those infringers who reject to perform demands stated in the takedown notice, and we have lots of tools on the pretrial stage. You may understand that litigation or even police raid is quite expensive, and therefore it's better to eliminate the threat on the pretrial stage, and therefore in this regard it is important to use additional steps, not just sending takedown notices. So it is indeed the most effective to cooperate with the registers of domain names, with the internet hosting providers, and we also have some agreements with some of them who can react very quickly to our complaints. And so we have a number of steps that can be undertaken besides just sending takedown notice. And even send, I will show it later on, a complaint with the public prosecutor who can be involved in this procedure, and it will not involve lots of money into this, but it's a very effective tool. And of course, if the pretrial stage wasn't successful in some cases, it will be necessary to think further and to discuss together with the local lawyer how to proceed further. It can be legal action or police raid with the purpose of termination of infringement and recovery of damages or compensation for infringement. And if you compare the activity and efficiency of actions of the global providers and local providers, so we can see that the efficiency is growing up, especially taking into account the steps that can be undertaken by the local team. And so when we speak about Russia, and it can be also said about neighboring countries, it's the most effective way to deal with infringements and use comprehensive approach, covering both online and offline actions. In most cases, it is possible to seize the infringements by just sending takedown notices, by talking with the infringers, by talking with the internet hosting providers, by using some Google DMCA procedures, and etc. But there are some number of percents, about 15% of infringements that are not terminated in this way, and therefore it's necessary to go offline for some actions in order to have the infringements removed. And therefore it depends on what is the purpose of actions of the right holder. If this is just sending the warning letter, so that's okay, you can do that. But if your main goal is to have the goods to be infringed and to punish, for instance, the infringer, like in this case, therefore you have to proceed further to offline actions. For instance, in this case, there was counterfeit product of Henkel, Priel, Balsam for washing dishes, and there was a fake product, and there was a factory in the Moscow region, and we managed to find this factory together with the police and make the infringer together with the police to destroy all counterfeit products. And I would say that this is the most efficient, just to impose fines, to impose some compensation in favor of the brand owner and destruction of products. This is the most efficient measure that can stop the infringers. As far as the internet cases are concerned, so there are the following main types of infringements. The first one is selling of counterfeit products, which are sold in different marketplaces, in social media, websites, etc. Parallel import goods. In Russia, I would say that parallel import is generally prohibited. But in some cases, it's very difficult to confiscate the goods from parallel importer. Under the Russian law, the parallel import goods, if they are original but imported into Russia without authorization, can be confiscated and destroyed only in case if they can affect the health of people, or they are poor quality, or if they cannot be used in Russia by some reasons, or they do not meet the requirements for storage of this product. For instance, if it can be the products for food, which can have special requirements for storage, etc. But if the goods are in good condition, therefore, unfortunately, it's not possible to claim the destruction of such products if they are parallel import. In this case, only compensation and ban on further importation of such products and the use of trademarks on these products can be claimed during the court procedure. And another one is phishing resources and fraud websites, which have purpose to collect information about the consumers, the users of the internet, about the payment details, addresses, telephone numbers, and etc. And actually, we have a lot of legal tools to act against these websites, and they can be blocked very quickly by the local authorities on the basis of complaint of the brand owner. And in this case, no litigation or the legal action is required. What is necessary to do is just to prove that the website is phishing or fraud website, and they do not sell original products. And also there can be infringements in social media and in domain names. This is just general types of infringements. This is information, for instance, about the phishing resources. So when doing some anti-counterfeiting work, so we faced with selling of products under the client's brands, and so we ordered the products from the seller, and instead of receiving the original products with the brand, we received that no-name backpack of very bad quality. And on the basis of this received information, we were able to prove that this is a phishing website, and it was blocked very quickly. Therefore, there are two main steps that can be undertaken against phishing resources. The first one, it's possible to file the complaint to the internet service provider or to hosting provider, and if they are persuaded that the website is phishing one, they block it very quickly within just a few hours. Simultaneously, it is wise to send the request to the domain name register for verification. This procedure is prescribed by the rules of local registers of domain names in .ru domain name zone, which provides that if the register requests for confirmation from the domain name owner about his data, including passport data, date of birth, name, etc., by documents, and if the domain name owner fails to produce such documents and fails to confirm his identity, in this case, the registration of the domain name can be cancelled. I would say that in most cases, the counterfeiters provide the registers of the domain name with false information, and therefore this request of the register for verification in most cases brings very positive results. They have just one disadvantage. It takes about 1 or 2 weeks, not just hours, but 2 weeks. But anyway, it allows to remove the infringement and delete the website at all from the registry within just 1 or 2 weeks and without substantial costs involved. But if, for instance, the infringer confirms his identity, therefore we can proceed with the second step, which includes sending a Tony Clause request to the domain name owner. We do it with the purpose to obtain personal data information. In Russia, personal data information is prohibited to be disclosed to people. It can be disclosed only upon the request of the law enforcement authority, court, or attorney at law. And therefore, we usually send attorney at law request to obtain detailed information about the infringer. That allows us to send cease and desist letter directly to the infringer, who is a private person. And in most cases, the infringer, when he sleeping at home and receives warning letter from a law firm, he may just drop this domain name and stop doing his legal activity with respect to a particular brand. If it doesn't work, we can send the complaint with the public prosecutor office and complaint with the personal data regulator authority, which is in Russia it's called Roskomnadzor. It's a very effective tool which allows also to block the website and remove it from the registry. So as you can see, we have a number of tools that can be undertaken to seize the infringement. If I speak about the illegal use of a trademark in a domain name, in Russia it's illegal to use somebody's trademark in the domain name without consent of the brand owner. And the Russian law provides liability for illegal use of the trademark in the domain name. So there can be also 3 main stages. The first one is, again, to send complaint to hosting provider just to block access to the website and to take down the website. The second one is also send a cease and desist letter to the domain name owner and file complaint with the public prosecutor in case we can prove that the goods which are offered for sale on the website are counterfeit. And according to the Russian law, public prosecutor is entitled to handle such issues. And if it doesn't work, it's possible to initiate litigation against the infringer. So this is the last stage. Of course, this is more expensive in comparison with the previous 2 stages. But anyway, it's also the last stage, but maybe the most effective one. And also during this litigation procedure, it's possible to claim recovery of compensation and legal costs from the losing party, from the infringer. I would like to say that with respect to domain name disputes, UDRP procedure is not applicable, and we don't have similar rules in the Russian law about the UDRP procedure, but all the disputes regarding the domain name infringement can be solved in court. Therefore, if we don't have successful results in handling the domain name infringement action in the pre-trial order, so the last instance is the court, and we can sue the infringer for this. And during the court procedure, we can ask some remedies, including the injunctive relief and revocation of the domain name and domain name transfer from the current owner to the brand owner. We can also claim compensation or damages and publication of court decision. When we deal with the infringement of trademarks in the domain name, there should be 3 main criteria met. The first one, there will be similarity of the trademark to the conflicting domain name. and the similarity is to be determined by court. Sometimes independent examination may be audited by the court in order to have information from some experts if it's complicated for the court to do it. But in general, in Russia, the courts decide these similarity issues themselves without involvement of experts. This is required only for the most complicated cases. And the second criteria is similarity of the trademark goods to those that are offered on the website under the domain name. As you know, the trademark is protected with respect to those goods and services which are stated in the trademark certificate, and therefore it's necessary to prove that these goods are offered for sale on the disputed domain name. And the Russian courts also take into account the priority of registration of the domain name and priority date of the trademark. And in order to proceed with the trademark infringement in the domain name, it is necessary to be sure and check before starting litigation that the priority date of trademark is earlier than the date of registration of the domain name. And so this approach was successfully applied in different cases, including in Disney, Warcraft, and Eurasian Couture cases. And the Russian courts take into account different circumstances when handling domain name disputes. For instance, in case regarding the domain name Nike.ru, the court took into account that the defendant owned more than 100 other domain names, and he didn't use those domain names, and all of them were offered for sale. Therefore, the registration of the domain name didn't have purpose for using it, this name in the activity, in the business activity of the infringer, but rather it was some material asset that the infringer intended to sell to the brand owner. And therefore, the defendant and the owner of the domain name failed to prove the legitimate interest and registration of the domain name. That was the reason for the court to satisfy the claims of Nike Corporation. In the case of Windows.ru, it was interesting that under the domain name, a company selling Windows, not software, but as a part of building, they sold these windows and provided the services for construction and repairing services for Windows. But nevertheless, the court decided that the domain name reproduced the famous trademark, and therefore the owner of the trademark couldn't use this trademark on the internet, and therefore the court decided this case in favor of Microsoft Corporation. And this is another example about ExxonMobil trademark Mobil 1, and in Russia this is quite popular brand, and there are lots of domain name, including mobiloil.com and this Mobil 1 shop, and etc. They use this brand in the domain name. And in general, if we speak about the domain name infringement, as I said, that the last option is litigation, and in general, litigation can be initiated with respect to each domain name. But in order to save the costs, sometimes it is possible to file a legal action with the court covering all found domain names infringing the same trademark, and therefore there will be just one litigation procedure, and it will be possible to save the costs for this action. Keywords is a very popular type of infringement on the internet in Russia, and maybe in other countries as well. And this quite complicated issue was several times discussed in courtrooms, and the Supreme Commercial Court created some precedent according to which the use of trademark in the keyword can be considered as the use of technical feature and cannot be considered as the use of trademark. And because there is no purpose of individualization of products, and therefore the trademark is not used as a trademark. It is used just as a technical feature. And therefore, in court practice, it is currently decision that the keywords in general cannot infringe the brand owner's trademark, because they are not a part of advertising, they are not available to public on the internet, because they are just a part of an agreement between the search engine and the advertiser. They are not demonstrated to the public and to the users by other ways, and they do not have some redirections to the advertising links and etc. But when considering this issue, not from the point of view of the serial law, but from the view of the unfair competition, the court agreed with the position that, okay, the use of keyword on the internet is a technical feature, it's not a part of advertising, therefore it doesn't constitute the trademark infringement, but it for sure attracts attention of consumers and end users to the website of a competitor. And this was possible only because of use of famous trademark. And therefore, this constitutes not a trademark infringement, but unfair competition, which is also prohibited under the rules of Paris Convention and under the rules of the Russian laws. And therefore, I would say that although the court practice says that keyword, that is the use of a trademark in a keyword does not constitute infringement, it still constitutes unfair competition. Therefore, it allows us to act efficiently against such unfair competitors. Another situation is with meta tags. Meta tags is a part of HTML code of the website, and the trademark is usually used in this code, which is not visible to public, but it allows the users to proceed to the infringer's websites, but by using the same trademark in search engine. And therefore, the Russian court practice has a strong stance in this regard, and the Russian courts believe that the use of the trademark and meta tag has the only purpose to use the trademark for the purpose of to attract the consumers to the infringer's website and mislead the consumers, and therefore it constitutes infringement. If we speak about marketplaces, social media and websites in which other people can leave their offers for sale or spread some online content, such companies or platforms can be considered as information intermediaries. Under the Russian law, information intermediaries can be, in some cases, also liable for infringement of IP rights, except those cases when they can prove that they do not initiate the transmission of materials, and the transmission of materials is performed by the users, and they do not modify materials in the process of their transmission, and the users upload and download information themselves without participation of the platform, and they do not touch these materials, and they weren't or should not have been aware of the fact that content is infringing, and upon the receipt of written notice from the right holder, they immediately took actions to remove the infringing content. When this rule was introduced in the Russian civil code, it allowed the brand owners and the copyright owners to more efficiently act against spreading of illegal content on the internet. Because after introduction of this rule, the platforms have become more cooperative with brand owners. And this is because they can be liable for infringement. And the Russian law says that compensation for infringement may be claimed from guilty information intermediaries. What it means? It means that if the brand owner sends takedown notice to the platform, but the platform ignores or still continues supporting the offer and does not remove it, they can be recognized as guilty, and even they can be claimed for compensation in favor of the right holder. And therefore, they usually prefer to be cooperative with the right holder. But if the intermediary is innocent, they anyway must remove the illegal content or restrict the access to this illegal content. So working with such intermediaries is also efficient tool that can be used for brand protection strategies. And the Russian law allows to claim from the infringer, would it be the infringer or platform, a guilty platform, etc. The Russian law allows to claim damages or statutory compensation. In most cases, the brand owners prefer to claim statutory compensation because it's not necessary to prove in this case the exact amount of damages suffered. And there are three ways of calculation of this compensation. The first one is the range between $160 till $80,000, and this compensation is to be determined by the court, depending on the circumstances surrounding the case and depending on the evidence provided by the parties. And the second option is to claim double cost of counterfeit goods, and in most cases it's quite efficient measure. For instance, in last case, which we handle now, the amount of compensation claimed by the right holder is more than $2 million, and this is based only on the basis of double cost of counterfeit goods. And under counterfeit goods, we mean the goods which were produced without consent of the brand owner. And the third option is claim double cost of the lawful license trademark usage, meaning the license fee. And if we talk about damages, it's more difficult to claim damages from the infringers because we have to prove by documents the amount of the sustained damages. We must prove the link between the damages and actions of the infringer. And in most cases, such documents which are required by court are not presented by the infringer, and they're not available to the brand owner. And meaning that it would be very difficult to prove all these circumstances and the amounts, and therefore there will be high risk of rejection of the claim. Therefore, most of brand owners prefer to claim statutory compensation, which doesn't have such strict requirements for evidence for proof. And so when we deal with online infringements, we understand that it's one of the most difficult types of infringements because there is difficulty in identification of the personality of the infringer, because most actions can be anonymous, and difficult to deal with huge volumes of infringements, because when you remove one offer, the infringer can create thousands of the same offers or links, and of course automatic tools are required. And of course it's very expensive to deal in an ordinary legal way with those infringements, meaning that it's not wise to sue for infringement every infringer. But anyway, we believe that in order to have the best strategy for brand protection, it's necessary to apply comprehensive approach covering both online and offline actions, including the communication with local marketplaces, local social media platforms, and use offline tools, including the registration of brand in the customs IP register, so that the customs could monitor the movement of the goods bearing the trademark through the border and prevent importation of counterfeit or parallel imports goods from other countries to Russia. And in some cases, when necessary, to initiate litigation actions or police raids. This is just a simple example of how it works. So in Russia, the goods can be brought by different ways through authorized channels and unauthorized channels. If the trademark is registered in the customs IP register, the customs will monitor and will prevent importation of unauthorized consignments to Russia. And only legal goods will be imported into Russia through customs. But there are also some illegal channels. And if there are no actions from the side of brand owner, all these illegal goods can be entered to the market. Therefore, as a law firm, as the practitioners in this area, we see in practice that those brand owners who take actions and deals with online and offline protection measures against selling counterfeit products, they have less counterfeit products on the market, meaning that the reputation of brands will be higher and the profit of local distributors will be higher, and etc. Therefore, we believe that if you would like to have a strong brand protection strategy for Russia, first of all, the trademark must be registered in the customs. The second, it is necessary to conduct online monitoring, as probably you do. And the third one, take offline actions, including investigations, monitoring of local markets, organizing police raids, and sometimes litigation, instituting litigation to recover damages or compensation and destruction of products. Only all these three measures can ensure the most efficient brand protection strategy in this country. So this is just brief information about how it works here. And so if you have some questions, please go ahead.
Hey, thank you very much, Evgeny. That was fantastic. Really enjoyed that. So we have been sent a question here from our audience, quite brief. Can you give us any idea of costs? I'm assuming that's in relation to all the strategies you've outlined already. Is there anything you can add on that score?
Yes. So as far as the cost is concerned, so there can be different costs depending on actions undertaken. For instance, if you speak about the registration of trademark in the customs IP register, it takes about $3,000 to include the trademark into the customs IP register for 2 years term. And during this 2 years period, the customs will monitor the movement of the goods through the border and inform the brand owner about suspicious consignments. This is, I would say, the most efficient measure. And as regards the litigation costs, we recommend to proceed with litigation only in the most complicated cases or when there is a good chance to get the compensation from the infringer. And before starting litigation, we usually conduct the financial research just to understand who is the infringer, if they have money which we can claim from them. Because sometimes they can just a paper company, and it's not wise to spend the client's money for litigation when we understand that we will get nothing from the infringer. And speaking about litigation, usually it's anti-counterfeiting issues litigation starts from $5,000 and depending on region, depending on the complexity of the case, etc., this amount may be increased and even up to $20,000. But everything depends on the circumstances and evidence and how far is the court from our place?
So it's very specific advice depending on each individual case. That's the overall message I'm taking from this. Is that correct?
Yeah.
Okay, brilliant. Well, thank you very much for that. I think we'll leave it there. If you would like to, if any of the listeners would like to receive some of those detailed slides, please write your email address in the feedback box and we can get those sent over to you. This webinar will be available on demand for the next 12 months, so please forward it on to anyone who you think may be interested. And also, don't forget to leave any other feedback in the box via your screen. It really helps us and the presenters next time. So it just remains for me to thank Gorodissky for its support and to thank Evgeny for sharing his insight today. So please look out for... Yeah, thank you very much, Evgeny.
Yeah, thank you, Tom, and thank you, everybody, for listening to me. And indeed, if you have questions, so we are always available by email.
Yeah, absolutely. Send it all over to us in the feedback box, and we will make sure that Evgeny receives it. So please look out for any future webinars from WIPR, and we hope you'll join us again.